Fire Safety for Landlords and HMO Owners, Part 1, Your Legal Duties, England. As a landlord or HMO owner, you're not just providing a roof over someone's head, you may have legal duties for fire safety in the areas you control. If key checks are missed, alarms are defective, or escape routes and fire doors aren't properly managed, people can be put at risk and enforcement action can follow. In this short video, you'll learn the main duties in plain English. Under the Regulatory Reform, Fire Safety, Order 2005, the responsible person is defined in law. Fire safety duties can also apply to anyone else who has control of the premises to the extent of that control. So in HMOs and other multi-occupied buildings, it isn't always as simple as it's the agent's job. If you own or manage an HMO, a block of flats, or a house converted into beds, be clear who is responsible for the common parts and what is actually being done and recorded. In England, there are 3 key legal areas most landlords should understand. First, the Regulatory Reform, Fire Safety, Order 2005, which includes duties around fire risk assessment and general fire precautions where it applies. The Fire Safety Act 2021 also clarifies that, in multi-occupied residential buildings, the fire safety order scope includes the building's structure, external walls, and flat entrance doors. Second, housing law, including the Housing Act 2004 and the Housing Health and Safety Rating System, which local authorities use to identify and act on hazards in dwellings, including fire. Third, the Fire Safety England Regulations 2022, which had specific duties in multi-occupied residential buildings, including resident information and extra requirements for buildings over 11 meters. So what does this mean in practice? If you are the responsible person or you control relevant parts of the building, you must make sure fire safety arrangements are in place, maintained, and kept under review. In plain terms, get a competent fire risk assessment for the common parts, complete the actions, and keep evidence. For standard rented homes, landlords must fit at least 1 smoke alarm on every story with living accommodation. Landlords must also fit a carbon monoxide alarm in any room used as living accommodation that contains a fixed combustion appliance, except gas cookers. And the required alarms must be checked as working at the start of each new tenancy. Under the Fire Safety England Regulations 2022, residents must be given fire door information, including the importance of fire doors and why they must not be tampered with. If the building is above 11 meters, the responsible person must use best endeavors to check flat entrance fire doors at least every 12 months, check communal fire doors at least every 3 months, and keep records, including where access isn't granted. If these duties are ignored, enforcement action can follow, including prosecution. And many cases start with issues that are entirely preventable, like missing detection, blocked escape routes, or fire doors that don't close properly. The good news is that most landlords can achieve solid, defensible compliance with a systematic approach: assess, act, record, and review. In the next videos, we'll look at what a good fire risk assessment should cover, practical guidance on alarms and fire doors, and how to communicate fire safety information clearly to tenants. If you're a landlord, agent, or HMO owner and you're unsure whether your current arrangements are adequate, use the contact details in the description to discuss a proportionate, UK-compliant fire risk assessment.